emotional outbursts during the trial of this case, notwithstanding the substantial efforts of the court to ensure that they don't take place. And we have had civil rights icons sitting in here in what the civil rights community contends is a quote-unquote test case for civil rights in the United States, eyeballing these jurors, including one today with his mask down, which the court doesn't want to make part of the record, under Supreme... I rephrased that, didn't make part of the record. Yeah, I rephrase.
You made it part of the record.
Well, until the court acknowledges it, it's not part of the record.
Keep going, Mr. Coffey.
Your Honor, the case law out there in mob cases and other cases demonstrates all the ways that presence in a gallery can influence jurors in a case. And I certainly don't mean to suggest that Al Sharpton or Jesse Jackson or any other pastor belong to a mob, but at the same time, we are talking about organized behavior by whoever outside the courthouse leading up to this case, where we have all these community leaders fearful that the city's going to burn down. This isn't a mob case. If you testify against a gangster, they might burn your house down. They might burn your business down. They're not going to burn your whole city down. And that is the concern that I believe jurors have expressed during the voir dire process, in that a county commissioner, a mayor, school board member, a bunch of pastors in this community, both black and white, have been talking about. So in that context, we believe the totality of the circumstances, which is what this court looks at under Shepard v. Maxwell, under the totality of circumstances, this trial has been sufficiently infected, notwithstanding the best efforts of the court, to the point where Mr. Brown's ability to receive a fair trial has become an open question. We think that line's been crossed. The court may see it differently, but we've made that for purposes of the record.
Just briefly, Judge. On behalf of Travis McMichael, we're constrained to join. I did notice jurors, a few, noticed the outburst. I don't think it gets any more difficult at moments like this for the family members to have to sit through the evidence. This moment feels unique in that the one piece of evidence that the state put up was not, so inflammatory, but there were several jurors that did look over. Their faces changed, the emotion, the sympathy that they felt, and to see then Mr. Reverend Jackson, whose autographed picture hung in my mother's law office for 2 decades, who is the ultimate figure of fairness and justice and equality. To see that, I don't think it gets any higher in terms of the impression that makes. And for those reasons, I think that makes this very unique. And that's why we're constrained to join, Your Honor. Thank you.
Likewise, on behalf of Greg McMichael, we are constrained to join this motion, but for some slightly different reasons I'd like to highlight. It was apparent from the beginning of voir dire that it was going to be difficult, even long before voir dire, that it was going to be difficult to get a jury who had informed opinions, and we worked very hard to do that. And we would have loved to have had a jury that represents the demographic composition of Glenn County, which would have been 3 or 4 African Americans on the jury. We were not able to do that. I think some comments by the court in denying the state's reverse Batson motion, I take exception to them, and with all due respect, but it's continued the difficulty we've had from the beginning in trying to determine, is this the right venue for this case? We hoped it would be. We wanted it to be. But in light of what's going on now and what has been the history of this case up to now, we are constrained to join the motion for mistrial, but for these slightly different reasons.
And Your Honor, let me be clear. I don't know what this talk about change of venue is. There's nothing wrong with this venue. We're not concerned about the venue, but we are concerned about the details as to how this trial has progressed, notwithstanding the extraordinary efforts that this court has made. And I certainly don't want the court to think for a moment that Mr. Brown and I don't very much appreciate the incredible amount of work the court has put into this and the thoughtfulness. But if the court's not going to grant a mistrial, I would humbly urge the court to consider adopting other precautions to ensure that the court doesn't wind up where the court has to grant that motion.
Anything from the state?
Yes, Judge. A mistrial is a proper remedy for incurable fundamental unfairness in the proceedings. There's a case from 1999, Casey, C-A-S-E-Y versus the state, 237 Georgia App 461, where jurors briefly saw the defendant in handcuffs, and that did not require a mistrial because there was no showing of actual prejudice. Quickly looking today, right now on Lexis, what we have is also Byrd versus the state, B-Y-R-D. This is a Supreme Court of Georgia case from 1992. It's 262 Georgia 426. Basically holding that because the trial court took prompt, thorough, and curative action, the outburst of the victim's relative did not deny a defendant a fair and impartial trial, and his motion for mistrial was properly denied. This court obviously took prompt, thorough, and curative action by having the jury leave immediately. In addition, don't want to cite something before I actually read it, so I'm going to take a look at it. We have Simmons versus the state, 308 Georgia 327, a March 13th, 2020 case. Simmons contended that the trial court abused its discretion when it denied his motion for mistrial in response to, and they put these in quotes, emotional outbursts of the victim's family members and friends. However, the Georgia Supreme Court saw no abuse of discretion. They then cited two numerous cases there, stating that trial courts are vested with great discretion to grant or deny mistrials because they are in the best possible position to determine whether one is actually warranted or not. Measures to be taken as a result of demonstrations and outbursts which occur during the course of a trial are matters within the trial court's discretion. And of course, such discretion will not be disturbed upon appeal unless there's a showing that a mistrial is essential to the preservation of the right to a fair trial. This was minor weeping in the back, and the court took immediate curative action. Additional action can be taken to instruct the jury there to ignore any sort of emotional outbursts that take place. And at this time, Judge, we ask that you deny any sort of mistrial based on the outburst, well, it really wasn't an outburst. It was, in the state's position, it was kind of a gulp and a weep, like that. And that was basically all it was that the state heard. So I just want to make sure that characterization, it wasn't somebody shouting, it wasn't somebody, as they say, falling out hysterical, nothing along those lines at all. So we ask that you deny any motion for mistrial on that basis. And ask that the court take kind of into consideration and disregard the, how am I trying to say, the mixing up or confluence of multiple arguments about Reverend Jackson being here and that somehow having something to do with the outburst or something like this. These are all very, very separate issues, neither which independently or even together at the same time require manifest necessity for a mistrial. We ask that you deny that mistrial.
And I believe that the last word.
Yes.
Law v. Shepherd, the court's looking at the totality of circumstances here. And under the totality of circumstances, we believe that a mistrial is warranted. I think the states has certainly accurately summarize the relevant law with respect to the court's discretion and with respect to whether an appeals court would reverse a determination by this court. But still, ultimately, it is Your Honor who makes that call. And that's why you get paid the big bucks, because you're the one sitting here as the umpire in the case, the advocates. We all see things from our perspective. You're the neutral here, and you make the call. But I would just admit, under the totality of circumstances in this case, from the commencement of jury selection to today, that these defendants can no longer get a fair trial.
It appears, Your Honor, there's some language in these cases about what is now incumbent upon the court. Until the state has to hold the trembling hand of the accused, I would suggest that these types of moments don't impact the state. They favor the state. And it is now incumbent upon the court to decide to grant mistrial or to present curative instruction.
I've asked for curative instruction as an alternative at this point.
Yeah. Well, the idea that you have to then potentially inquire of jurors and ask them if they heard it and if they noticed it, we're not asking for that. However, we're at 2 strikes. We've had one outburst that's been addressed. Now we've had a second. The court has to decide what to do.
All right, anything final, Mr. Hunter?
No further comment.
All right, it's in this court's discretion with regard to any outburst in the courtroom, taking into consideration as well as the defendant's motion for a mistrial. So I cite to a couple cases. Let's see, Forney, I think it's Forney versus State, 255 Georgia 316, which actually recognizes that emotions are neither unreasonable nor unexpected during a murder trial. And the demonstrations and outbursts which occurred during the course of the trial are matters within the court's discretion to evaluate. The court heard exactly what I described on the record, decided to remove the jury briefly, and it was ready to get started. Based on that outburst, the court is not granting a mistrial. As to the totality of the circumstances argument, which I think is the second argument that was presented by Mr. Goff, that gets back to what I'm starting to watch very carefully as far as what's going on in this courtroom with the jury, as well as the arguments that are being made by counsel. I'll point out that a number of times during jury selection, it was raised that jurors were being influenced by individuals outside the court. And I think it was either 4 or 5 jurors were asked specifically whether or not they were influenced in some way by what was going on outside the courtroom. And they were not. There was no, actually, if I remember correctly, they didn't even recognize or see what was going on outside the courtroom. And as counsel are aware, because I have briefed counsel, there are steps being taken by the court during the jury trial to ensure that jurors are not influenced by anything happening around the courthouse. So then we start getting into what we have now with individual members or individuals coming into the courtroom. I will say that is directly in response, Mr. Goff, to statements you made, which I find reprehensible. The Colonel Sanders statement you made last week, I would suggest maybe something that has influenced what is going on here. In response to that, and to his credit, Mr. Sheffield made some comments, but did say, come one, come all. And so now the court is faced with balancing a lot of things going on outside this courtroom and doing it in a way that respects members of the public's right to be in the courtroom, as well as what I'm trying to put out there is a fair trial, right? So you need to understand, everybody, that your words in this courtroom have an impact on a lot of what's going on. And so my measured response at this point is to balance all of that out and try to move forward with the trial. I'm not granting a mistrial at this point based on these arguments that are being made, because I think, well, I'm not granting a mistrial at this point based on the arguments that have been made. Are we ready with the witness from the state? Be Mr. Sheffield.